I haven't spoken to them in years. They're dead to us. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover an estranged family member in the context of probate. A common situation arises in which we're gathering the family tree, the information necessary to open a probate estate and to provide a list of the family members of the person that died. This process can be quite emotional because when we get to that one family member that is no longer communicating with the family or maybe has been estranged for many, many years or decades, when we get to that family member, the person that's providing us with the information often pauses and says, they're just not part of our family anymore. Let's not include them. Well, an estranged family member is still a part of the family. What I mean by that is by blood or consanguinity, that person is still an heir of the decedent and still under the court rules is required to notice. Now we have to differentiate because there are those estates in which there is a will or a trust that guides who is going to distribute and receive the estate assets. And then of course, in the bulk of the estates that get open, there is no will that guides the distribution pattern. But even with a will or without a will, when notice is being provided to open up the probate estate, the court rules mandate that the heirs at law be provided notice. Notice of the opening of the estate, notice of the ask to open or to nominate a personal representative, and the notice of whether there's a will or no will. This noticing requirement requires that all the heirs at law be provided notice, not just those that you're in communication with. So an estranged family member is provided the same notice as the family member that is daily in communication with you. Now, there are certain situations in which the person has been so long removed from the family that people cannot identify their whereabouts. Michigan's court rules provide for specific instruction on how to give notice to those people by publication or other alternate means. The point is that when completing a family tree, all the heirs at law are entitled to notice. And in an intestate distribution, this means a distribution that occurs without a will, that person who has been estranged gets the same share as the other family members of equal level of relationship. This is really an important consideration if there's an estranged family member to ensure that you do an estate plan, creating a will to ensure that those people that you want to receive get that which they're entitled to. So yes, estranged or not estranged, notice is required under each circumstance, and the effect of an estranged family member, they don't just get disinherited because they have no longer communicated or fulfilled their familial obligations in the family. They get their share. So it's important to work with a skilled, competent probate practitioner in doing your estate planning. And then of course, after death, working with a skilled, competent probate practitioner to assist in the administration of the probate estate.